This is Secretary of State Jeanne Atkins.
Try not to do anything bad to the computer while we do this. Thank you for that welcome. And I hope I'm going to be a little bit brief because I think the person you really most want to hear from is Alana, who has the many years of experience giving good compliance advice, investigating complaints when they come, and can give you a lot of good information. But I did want to introduce myself and to welcome you to another election year. Hello, I'm Jeanne Atkins. I am your Secretary of State. 11 months ago, I was plucked from retirement and given the opportunity of a lifetime, a chance to serve my state and never have to run for election. I have been Secretary of State for 11 months, and I have 11 more months to go. That's not downhill, that's like straight up for all 22 months, and then I fall off a cliff. I've learned from my team of experts in the elections division about how an open presidential election season is where the turnout and potential for conflict are at their all-time highs. So I can tell you that in every county and at the state level, election staff are getting ready for a lot of work to happen between now and the end of the year. In Oregon, we will not only have the presidential race, we will have 4 of 6 statewide officials on the ballot. That is a U.S. Senate race, a race for governor, a race for Secretary of State, and a race for Attorney General. Not to mention any number of high-profile statewide ballot measures that may qualify, and of great importance, obviously, the local funding and bonding measures that local governments and school districts will be pursuing. I did want to take a brief moment to note and remind ourselves as Oregonians how foresightful we have been and what a national leader that we are in making sure that all voices can get heard in our election season. The fact that we mail ballots to every registered voter, we allow them to vote at their convenience and in private. For most voters, voting doesn't even require the use of a stamp. More than half of them now return that through the more than 195 ballot boxes that are placed in counties throughout the state. We don't have many of the problems that we see on the national news of frustrated voters who turn up at the polls and find they aren't even registered, or who come late and have to stand in long lines. And best of all, our turnout rates still exceed the national average on a regular basis. And so now we've added into the mix another new way to make participation easy, efficient, and secure, which is our new Oregon Motor Voter Program. This new program, which allows the Secretary of State's office to connect data from the DMV with our registration system, started up on January 1st. Individuals from now on who get a new or renewed driver's license, permit, or ID card, and who meet the requirements for voting, by age, citizenship status, and residence address, can be assured of getting registered and getting a ballot for upcoming elections without taking another step. Or they could take the step of declining to be registered. Yesterday, we were able to announce some data about what's happened since the beginning of the program. More than 14,000 Oregonians have received mailings from us indicating that their process of potential automatic voter registration has begun, and giving them the tools with which they can decline to participate or add a party registration to their registration record. The outcome of the first 6 days, which have run through their 21-day period where they have to respond, was that 4,358 new voters have been sent to county clerks to complete their registration. That's 6 days worth of mailings that came from the Secretary of State's office, and each day that builds. In context, I want to tell you that over the last 8 years, we averaged an increase of 2,100 registered voters a month in Oregon. So 6 days produced 4,358. We're going to have a lot of new voters in the registration system. In addition, by matching the DMV data with our voter registration database, we're able to keep the addresses for voters very much more up to date. Between January 1st and Groundhog Day, our last day that I have data for, we had updated address information for more than 17,000 voters. That means a lot more voters are going to get the ballot at their right address. A lot fewer ballots are going to come back undeliverable to the counties. And that too will assure that more people are able to follow through on their right to vote. It's very good news for participation for every individual having their voice heard. If you have any questions about Oregon Motor Voter, I'm happy to talk to you about them later. The lists that you get from counties, if you do any work with campaigns, we'll start to fill up with those as the months go by. But I do have one other thing that I want to speak briefly to you about. The Secretary of State is not only the Chief Elections Officer for the state. We have a good many other things we do: audits, archives, corporation filings, and a project from our archives division. I think there also is a little half sheet going around. We have started a fundraising campaign among school children, and so you're the right audience for me to bring this to. You may not know, but the gold man on the top of the Capitol, the pioneer, the gold was put on and fundraised for by Oregon school children who did that work. And so we are now inviting folks to help us with a project to both restore and protect the state's original Constitution. You may have seen something about this at some point. If you visit the state capitol next week, which is the state's birthday, you can actually see the original Constitution, which has to be kept in a box in a temperature-controlled room in the archives division because it is in need of preservation and because it will continue to deteriorate if it is not preserved. We need about $60,000 to restore it, improve the bindings, improve the paper and ink quality, and to build it a case so we can actually have it out in public. We're also doing a transcription because, as you know more than a lot of other people, we wrote in very, not just cursive, but very fancy cursive back in the day. And many school children could not read that Constitution at this point because they're not used to that. So we will have something that the display will include something that will help with that. We're inviting schools. We have invitations out, and we wanted to pass them along to you, inviting schools to help participate. I spoke to an elementary school set of fourth graders in Bend last week, or the week before last, and they got very excited about what they could do. Any school that provides $250 towards this goal will have their name on a plaque that will be displayed with the Constitution, so we'll keep a record of that. And also, if I come to your school or the archivist comes to one of your schools, we're also inviting them students to answer certain questions about our state constitution, and we will keep those all, if they're returned to the archives, in a special record of school children's responses and answers to questions about our state constitution. So that's an important project we're doing. I wanted to take advantage of my invitation to come here to commend it to you. There are half sheets, flyers. I don't know that we brought enough for the huge crowd, but please contact us or have your principals and district administrators contact us about that. And I'm going to turn it over to Alana Cox, the real star of this show, and again, happy to take questions afterwards, as is she. Alana, thank you.
All right, thank you. I am Alana Cox, and get to talk about something that I'm surprised to hear people are so excited to talk about. ORS 26432, the Little Hatch Act, which prohibits public employees from campaigning while they're on the job during work hours, and prohibits electeds from asking those public employees to violate the statute. So I'm going to kind of do some high-level points in the context of bond referrals specifically, because I think that's what you guys have been talking about. We did pass out some manuals that are, I think, on the tables, and I put my business card on those. I think if you have one takeaway from this, I hope it's that we're available as a resource to you as you encounter unique ideas and challenges around this statute. Call us and let's talk about it and hash it out together. So in the context of a bond, when do you have to start worrying about this statute? You worry about it when the notice of measure election is filed with your county elections office. So before that time, it's not a measure, it's just an idea. We're not really worried about ideas, we're only worried about measures. So Until that time, you are free to advocate, of course, and I know you do, and come up with a good plan and talk to your boards about it. And so it ceases to apply. This is a question that's been coming up a lot lately. 8 o'clock on election day. So if you want to have a party the next day and say, we did it, you can do that. No one's voting anymore. So it applies to all public employees while they're on the job during work hours, when they're acting in an official capacity. And so documents produced by public jurisdictions are always done in an official capacity. And I think documents are the biggest thing to be considering in the context of your bond election is how are you going to communicate about it on your website, on social media, are you going to send mailers? All of that information needs to be impartial with regards to your bond. And impartial means two things. It means you have to disclose the cost to an individual taxpayer if you talk about what your measure is going to do. So if you're going to build a new school, we're talking about the, $1.32 per thousand assessed value or whatever the calculation is. You have to disclose that on all your documents, and you can't explicitly urge that people vote for or against it. So no asking, no putting it in the context of an ask. And we are here to help you with these documents, and we offer a prior review service to let you know that the document is okay to go. We'll grant it safe harbor. We turn those around really quickly because we know you're under strict deadlines, and we want to make sure you stay in compliance. Another issue that's been coming up a lot in the last election cycle is what's the deal with contractors who are producing some of these documents for you, or your web content or whatever. Are they restricted? They are restricted in the sense that whoever is supervising your contractor, if you're using a PR firm or whatever, whoever is keeping an eye on what they're doing and approving what they produce, that person is responsible for that content. So we've been working with a lot of contractors doing prior review with them, and we're happy to do that, but it's not a big old loophole in the statute. So another thing I just want to point out in the context of bonds is equal access, and that's kind of everything for political purposes. It's to your buildings, to your public records, to new media, whose comments are you deleting on Facebook, who's using your school gym for a campaign event. We just ask under the statute that you treat people equally for political purposes. But the new manual really focuses on suggesting that you think about the policies you have in place and whether you have policies in place written down before these issues come up. So it may be, that you have a bond on the ballot and the PAC is formed to oppose it and they want to rent your gym, or they want to advertise in your football flyer booster club thing. It should be everyone can do that or no one can do that, and you're going to be really proud of yourself if you get in that situation. You said, we have a policy for this and we wrote it down. It's much better than reacting to the situation as it comes up for the first time. So, use of your facilities, public records, Facebook and Twitter has been a hot one. Which comments are you deleting? Can you point to that it's obscene and not that it's opposed to your bond or whatever it is? Posting political material in workspaces, use of government email. You just want to be thinking about those things before you're faced with the question, can I place this ad? Can I use your gym? Whatever. I'll just point out to you that it's external communication, it's also internal communication. So one of the biggest sources of complaints under this statute is staff themselves. When you're communicating with your teachers or administrators after the bond has been certified, that communication needs to be impartial too. And so something to keep in mind. I think it's where people get tripped up just in the accidentally wasn't even thinking about it kind of way. And you want to make sure as you're communicating with your staff off the job or on the job that you're never implying that something great will happen to them if they help you pass the bond, or that something bad will happen to them if they don't, right? So that seems obvious, but let me tell you, it's worth keeping in mind. So I want to make sure that I leave plenty of time for questions and just kind of hit on the highlights, because this statute is really about what exactly you want to do, what's your strategy, and how can you do that within the context of the law. And it never ceases to amaze me, the creativity of different jurisdictions. I think I've got it down, and a question comes in, and it's like, that's a good one. Let's think that through and talk about it. And so, do we have some questions? And there's a microphone that will be floating around to help on that.
I have a question. If the school board lists the reasons for going out for a bond, and they sound like advocacy, our schools are deteriorating, we need additional space, they go into enumerate all those reasons, we put it in our newsletter and we send it out. Are we advocating by enumerating all of those causes, and how far can we go in the descriptors and really making them sound enticing to the voters?
That's a great question. So the question was, can we list out all the reasons, what we're going to do with the money if the bond passes, and why we're going out for the bond in a newsletter or other document? The answer is yes, you can do that. You can use adjectives in that. That's where the cost comes in. So the idea, we tried to create some brighter lines back in 2012 when we kind of redid the whole policy around the statute. And we decided that if you're disclosing to a taxpayer what their burden will be, you can also fully disclose how you're going to spend the money, why you want it, why you need it. So that gives you a lot of freedom to create that list of, what you're going to do and why you're going to do it, as long as they also know it will cost them whatever it will cost them. And so that's kind of in a per document thing, that in any individual document, if it's a postcard, if it's your website, you can fully describe why you want the measure to pass without the ask, without saying we ask that you approve it, and with disclosing the cost. Sure.
And if there was a retiring bond, had language that said which will not raise your taxes.
Yeah. So the question was, if you have a bond that's retiring or expiring and you're replacing it, can you say this will not raise your taxes? Yes, you can say that. But we ask that you also say it will maintain a rate of whatever the rate is. But you can say it will be a raise in taxes. Yes, that question comes up a lot.
First, I want to
start with a compliment, Alana. I'm Randy Training from Corbett, and you are perhaps the fastest official in all of Oregon in approving things for St. Barbara. I am amazed. And secondly, could you explain the different role that school board members can take in an advocacy campaign after it's been done compared to superintendents or other administrators?
Yeah, that's a great question. And to the first point, I meant to point out that we have a new staff member who's going to be working on this issue. Her name is Sherry, because we know you have expectations of speed and we want to meet those expectations. So we've doubled our staff on this issue, so we're ready to turn it around for you. But the question was, what's the difference between a school board member and everybody else? And school board members are elected officials. The statute specifically says elected officials are not public employees. But elected officials cannot use any public employee work time in any way to do any of their advocacy. And I think the main context this comes up in is like quotes or letters or whatever that are included in some other document that are from your board members. So if you have a board member who wants to do a letter in opening your newsletter, that letter has to be impartial too, because that newsletter is probably being formatted and distributed, and all of the work putting it together is being done by public employees. That's on behalf of the jurisdiction. But in terms of going out and speaking and on their own, board members are not restricted, and they're fully, allowed to advocate for these things. But the superintendents down to the bottom, they're public employees, and they're restricted.
One of the things I just wanted to clarify, first of all, you do a fabulous job on reviewing things under 260. One of the things the Secretary of State's office won't do is look at your explanatory statement or your ballot title. And those also have to be included. And things like saying the taxes won't go up for a bond measure, of course, you can only estimate what your taxes are going to be to pay your bond issue. So you'd have to say it's estimated and things like that in the explanatory statement and in the ballot title, but Alana's done a great job of those. Thank you.
Yeah, that's a great point. We do not review ballot titles or explanatory statements for impartiality, but we also will not penalize you for a ballot title or explanatory statement. Those have their own challenge process, their own impartiality requirements, so we kind of consider those their own animal outside of the statute. Sure.
Along that same lines, can you differentiate between a superintendent and, let's say, a site principal and a site secretary, what they can and cannot do? Is there differences?
There are not differences. So no matter where you are in the spectrum, if you are not elected, then you are a public employee. And I should also point out that includes your appointed boards and commission members. I'm not sure how common that is in the context of school boards, but so if for a city, if they're appointed planning commission, they're public employees too when they're acting in their capacity as a planning commission member. But your principal is restricted in the same way that your janitor or bus driver or teacher is restricted. That they're all public employees and they cannot advocate for or against a measure while they're on the job. Yes. Did I misunderstand the question?
Does the superintendent have the same freedom to, in theory, in off hours, to be able to advocate?
Yes, they have the same freedom as a principal to advocate off the job. So that I think I see what you're getting at. So this is the kind of official capacity question, and so everybody knows the school superintendent or principal. Even when they're at the grocery store, they might come up to them and ask them questions about school or whatever. So everybody has a First Amendment right to free speech, to political activity when they're off the job. So what I recommend for those people in the community who are well known for their position and people kind of think they're on the job all the time is that if they want to go engage in some advocacy outside of work time, on their lunch hour, they want to go make a speech to the Rotary Club, or after work, they want to go attend some meetings and advocate for passage of a bond. They can absolutely do that. They should announce to the audience, we recommend that they let people know, I'm here in my personal capacity, I'm not here in my official capacity as principal or superintendent. And we also recommend that they do a little note keeping so that if anything comes up later, they have some way of noting, I was off the job, that was my lunch hour, I took a half day, a vacation day that day so that I could go engage in some political activity.
Along those lines, can an employee, a public employee, on their own personal time outside of work hours, produce materials, newsletter, collateral items for advocacy of the bond? Or if so, do they have to state something like you said before, or how would that work?
Yeah, that's a great question. There are kind of some overlapping issues there. So threshold, if that newsletter or document or whatever it is going to be on behalf of the jurisdiction, if that's going to be a school district or school newsletter, then that's always going to be undertaken in an official capacity, and it doesn't matter if it's midnight on a home computer. But for other documents, if they want to go work with the PAC in their personal time to produce documents, absolutely they can do that. And absolutely, I would recommend, not that they announce it on the document or anything like that, but that they keep track of how they're using their time, just in case any issue comes up about it. So that, especially if it's during normal work hours, if they're going to take some vacation time and maybe it's an informal environment that they wouldn't normally notate that, I would recommend notating it for these purposes. And then there's kind of another issue in there, maybe not what you're getting at, but kind of things like, can my principal do a letter to the editor in her personal capacity? Yes, she can, and she can use her title. So that's another thing that it's a really good idea for her to document that, I did this on a Friday night on my home computer after hours, I submitted it, I approached the newspaper, all of those activities took place outside of work hours. But one thing that's a little new in this manual is titles belong to the public employee, and they can use those outside of work time and outside of their official capacity. So it's okay for a superintendent or a principal to do a letter to the editor and use his or her title, but they should not in that letter to the editor say, hey, I am here speaking on behalf of the school district, letting you know why we should pass this bond. It should be in a personal capacity. I think there's a question up here.
If a board member works for a municipality, they still fall underneath the public employee rules, just like if you work for the school.
Absolutely, yeah. So if the question was if a board member works for a municipality or is a public employee as their day job, they're not becoming a millionaire being a school board member, I guess. So yeah, absolutely, they are public employees in whatever it is that they do. And so while they're on the job during work hours during that job, they should not be engaging in advocacy activities.
What about endorsements or ballot statements? Would that be acceptable, for example, for a superintendent to write one, or for a staff member to provide an endorsement of some sort using their title?
Sure, so the question was, what about endorsements and like voters pamphlet
Yeah.
information? Can they use their title for those things? Yes, they can use their title for those things. But one question that's come up recently is, can a group off the job, or sorry, on the job, can a school district or whoever submit a measure argument that's impartial? That's not your question, but I'm going to answer it anyway because it's like something in the ether that's been coming up a lot lately. You can never do a voters pamphlet measure argument impartially because you have to file it as support or opposition. And so, so your explanatory statement, that's your impartial statement on the measure. But yes, a principal could endorse it with their title, or a superintendent could use their title, as long as all that endorsement activity takes place off the job. So, you know, they should be keeping track that they were asked and they answered, you know, they were asked for the endorsement and they gave the endorsement outside of work time.
Maybe that's what I meant as a measure argument. So a measure argument in favor, could that be?
Yes, so a measure argument in favor, that can be done outside of work time, and that would be allowable. It cannot be done on behalf of the jurisdiction, as that's one of those things that's always in an official capacity and always you have to pick yes or no for measure argument, so it's hard to be impartial on this. Any other questions? All right, well, I'm available, so call me.
So I really want to thank Secretary of State Jeanne Atkins and Alana Cox. This office is open, accessible, and helpful, and we just so appreciate the expertise you share with each of us. So do try to reach them, and we also have their resources available on the OSBA website to assist you. This afternoon, we're going to build on this morning's efforts by offering 2 blocks of 3 workshops each, from 1 to 2:30, and then from 2:45 to 4:15. You'll then have another opportunity to network with our partners. They're making their time for you from 4:15 to 5 o'clock when our conference concludes. So thank you again for a great session and enjoy the afternoon.